Osiphesona Ngcanga has been released from prison after 2 years for a crime he did not commit. He was arrested and convicted for allegedly raping an unconscious girl at a party. 2 High Court judges found that the magistrate who sentenced him overlooked shortcomings in the evidence. So what happens when something like this takes place, and who should be held accountable? Joining me to discuss this is legal expert, that's Nthabiseng Dubazana from Dubazana Attorneys. Nthabiseng, good morning. Thank you very much for your time. For me, this story is sad on several accounts. There was a young woman who was raped, obviously, and then she said, I've been raped. But then there was a man who was pointed out as a perpetrator, as the alleged rapist, who turns out was not the rapist. And now he spent 2 years in jail. He was jailed for 8 years. He spent 2 years. He's now out. I mean, what can you do in such a situation? Legally, what is his recourse now? What can he do?
Well, now what he can do is now sue the state for wrongful arrest and wrongful detention as a result of him being found not guilty on appeal. So now what he can do is his legal team that assisted him in the appeal can now assist him in getting the wrongful detention civil suit started. So basically, he will then sue not only the Department of Justice for the magistrate who then sentenced him in this situation. It is quite possible he can also sue the magistrate in his personal capacity as well. And also, he will then also sue the Minister of Police for the arrest as well. For it's a wrongful arrest because now he was found to be not guilty.
And this process of suing all these different parties to this will take time.
It would. It would take a very long time. So there's a 6-month window period whereby once you become aware of the situation as a legal representative, for you to now inform the state organizations, that will be the DOJ and the Minister of Police, that write them a notice informing them this is the situation and we intend to start legal proceedings. Should that legal proceeding not start within those 6 months, your window is closed. You cannot sue the state after that.
Minister Ronald Ramula was warning all of us the other day that we shouldn't be attacking judges and the judiciary in public. But if you read what the 2 High Court judges said in upholding his appeal and overturning the original judgment by the magistrate, they used words like it was a misdirected approach. They used words that the way the magistrate considered, evaluated the evidence and the credibility findings in favor of the state witness overlooked material shortcomings and discrepancies in the evidence. That's damning towards that magistrate.
Very true. That's why when you are sitting and presiding over a matter, you need to open your ears very clearly so you can hear the evidence for what it is. If in evidence in chief, this is the story, but under cross-examination, a different story comes up, it doesn't mean you don't regard that information because it's under cross-examination. It's evidence under oath. So if there's already contradictions between the evidence in chief and cross-examination, there's already an issue.
So in this case, can Mr. Ngcanga, Osiphesona Ngcanga, or should he approach the Judicial Service Commission? How do you go to sue against a magistrate? How does that take place?
Go get yourself an attorney who will then start the processes for you. So it is just basically the notice, like I said. Once the notice has been served after 30 days, then summonses can...
So it's a similar approach as well against the Department of Justice.
Correct, so.
And then the correctional services,
yes.
And everybody held him. And I said when I started this discussion with you, there's a said on many fronts, the one that somebody was raped now, she won't know who's the guilty party, who that person is maybe walking free, we don't know. That's very tragic. I mean, gender-based violence is bad in this country, isn't it? And on the other side, Mr. Osiphesona Ngcanga, he was studying. He was doing his master's at the time, degree from the reports that I've seen, and all he wants now is to conclude. He just wants to register at the Nelson Mandela University to finish his master's degree. I mean, 2 years of his life gone nowhere, and he's been marked by the trauma of spending time in jail for something he didn't do.
Very true, and also not only was he a master's student, but also a lecturer. So now his career was also disrupted.
Credibility.
And all of these things. But it shouldn't be a problem to be reinstated.
Yeah, now as we conclude here, Ms. Dubazana, how often do we see cases like this in South Africa? As an attorney, how many more cases are there? I mean, maybe you don't know the specifics, but this is not something that just happened. We do have these cases that happen?
Way too many. It's unfortunate to say that, but way too many. That's why the state seems like sometimes it's overworked. The state, as in the NPA, they don't have sufficient prosecutors to help with cases. The magistrates also, there's a shortage. So sometimes magistrates are overworked and they have 10 judgments and sentences in one day. This happens way too often. And then unfortunately, we are there to then sue the states because these people have suffered as a result of human error in not paying particular attention in a matter that you're dealing with on that day.